Breaking into the property market has never been tougher for young Australians, and many parents are stepping in to help. That support can look very different. Letting kids live at home rent-free, covering their expenses, gifting or loaning a deposit, acting as a guarantor, selling a property below market value, and many more. But here's the catch, these choices may have unintended impacts on your age pension. In this video, part 1 of the 2-part series, I'll walk you through the first set of common ways parents help their children and explain how Centrelink treats them, so you can stay informed, avoid traps, and make smarter choices for your children and your future. In part 2, I'll cover the rest, so you'll have the full picture before making any big decisions. Before we dive in, it's important to understand Centrelink's gifting and deprivation rules when it comes to age pension assessment. These rules are designed to discourage people from giving away assets just to qualify for more pension. You can gift up to $10,000 in one financial year, with a maximum of $30,000 over 5 financial years, without it counting against you when Centrelink assesses your age pension. These values are called the gifting-free areas and are the same if you are a single person or a couple, meaning if you're part of a couple, you don't get double the thresholds. You can choose to give away any amount and as many gifts as you like. However, if the total value of your gift exceeds the gifting-free area, the deprivation rules apply. Centrelink will count the excess, known as a deprived asset, in your assets test, and deem that access to be earning income and include the deemed income in your income test. This applies for 5 years from the date you make the gift, even though you no longer have the money. Both the higher asset value and the deemed income can reduce your age pension, or even stop your payments altogether, along with your pensioner concession card. Now let's talk about the many forms of support, starting with letting your child live at home rent-free or at below market rent so they can save for their own home. Whether it's an extra room, a self-contained living area, or a granny flat in the backyard, having an immediate family member like your child live there can be a win-win. Under the assets test, your principal home remains fully exempt. Under the income test, even if your child contributes something towards rent, groceries, bills, or general living costs, these payments are not assessed as income for age pension purposes. From a tax point of view, if the payment from your child is in the form of board and lodging, rather than a normal commercial rental arrangement, is considered of a domestic nature, this means you don't need to declare it as income or pay tax on it. Other common ways parents help are gifting a deposit or covering other upfront costs associated with buying a home, like stamp duty, legal fees, or moving expenses. Some also choose to help by paying off their child's debts, such as a help debt, car loan, or credit card balance, to improve their child's borrowing capacity and financial position when applying for a home loan. From Centrelink's perspective, it doesn't matter whether you give the money to your child to cover these expenses or you pay these expenses directly on their behalf, it is considered a gift. Any amount above the gifting-free area will be treated as a deprived asset, which will be added back to your total accessible assets and deemed to earn income for 5 years from the date of the gift. If the gift was made more than 5 years before you become eligible for the age pension, the assessment period has expired and it won't affect your entitlement. This really shows why it's important to plan ahead if you want to support your family without reducing your future age pension. But of course, the situation might not allow for early gifting, and there are many other considerations. You should always weigh things up carefully before making a final decision. Which brings us to the next point. Gifting is simple, but the problem is you lose control over that money, and there is no way to undo it. Things can get especially complicated if your child goes through a relationship breakdown. Imagine this. You gift $300,000 to your child to help buy their first home. Later, your child separates from their partner, and that partner claims half the property. That means half of your gift could end up with the ex-partner, and there is nothing you can do to get it back. To avoid this, many parents choose to structure the support as a loan rather than a gift. To do this, a formal loan agreement is essential. You can tailor the terms, including the interest rate and repayment schedule, to suit both you and your child, or even make the loan interest-free if you prefer. From a Centrelink perspective, a loan provided to someone like your child is not treated as a gift. Under the assets test, the outstanding loan balance is included in your assessable assets. Importantly, any interest payable is not included. Under the income test, the loan is treated as a financial investment, meaning the deeming rules apply to the outstanding balance regardless of the interest charged, or even if no interest is charged at all. Hey, if you're getting value from this video so far, please take a moment to like and subscribe. You really help the channel more than you might think, and I really appreciate the support. Thanks heaps! Now, some parents choose to forgive the loan at a later stage. Maybe the original concerns, like the risk of relationship breakdown, no longer apply, or perhaps your child's financial situation has changed, or you simply no longer want the money repaid. But the moment you forgive the loan, Centrelink treats that as a gift. And if the amount forgiven exceeds the gifting-free areas, the excess amount is treated as a deprived asset. Special rules may apply to failed loans. If you're in this situation, I've included a link below with more details. Another common way parents help is by acting as a guarantor on their child's home loan. There are many important legal and financial considerations when doing this, but in today's video, I want to focus on the age pension implications. Agreeing to be a guarantor does not involve giving away assets, so it does not trigger Centrelink's gifting or deprivation rules at the time the guarantee is made. However, if things go pear-shaped and your child defaults on the loan, you as a guarantor will be required to repay it. Centrelink's assessment of repaying the borrower's loan depends on what action is taken by the guarantor after repaying the loan. If you pay the loan on your child's behalf and later take legal action to recover the amount, then deprivation rules do not apply. The amount you repaid is treated as a debt owed to you. This means the recoverable value is counted as assessable asset for your age pension. But deeming does not apply in this scenario, so no income is included in your assessable income. If no legal action is commenced, the amount you repaid is treated as a gift. Any amount over the gifting-free limit is considered a deprived asset, which will be added back to your total assessable assets and deemed to earn income for 5 years from the date you repay the loan. This concludes part 1. In part 2, I'll go through the Centrelink implications of transferring a title of a property to your child, co-purchasing a home with them, selling a property at below market value to them, gifting an income right, and more. So make sure you watch that as well to get the full picture. If part 2 isn't available yet, I suggest watching this video. Most people don't realize that if you leave your super directly to your adult children after you're gone, they could lose up to 32% of the balance to tax. In that video, I share strategies to reduce or even eliminate this hidden inheritance tax, so more of your money goes to your children, not the ATO. Thanks for watching. I'll see you in another one.